The judge in the Trump case contributed to the Biden campaign. This is absolutely insane. You got to watch this.
Back. The gentleman from Florida is recognized for 5 minutes.
We are here at the hearing on the Manhattan District Attorney's Office, and the essential ingredient we seem to be missing is the Manhattan District Attorney, which I guess, Mr. Roy, would be a lot like going to the Salt Lick Barbecue and not getting the moist brisket.
Ranking Member Nadler, members of the committee, thank you so much for the opportunity to testify today. I'm going to focus my remarks on due process as a constitutional lawyer and someone who practices in the field. Most of you went to law school, so you remember that due process is part of the Constitution that ensures that the processes employed to deprive someone of life, liberty, or property are fundamentally fair. And of course, we all learned that there are twin pillars of due process. One is notice, and in the criminal context, that means notice of the specific charge that you face, as well as the issues that are raised therein, in other words, the elements of that crime. And number two, a meaningful opportunity to be heard on those charges. And unfortunately, Mr. Trump's New York trial violated both of these twin pillars of due process. And to explain why, first of all, I've attached a flow chart to my written statement that might be helpful as I go along through my oral testimony. But I thought I'd also bring another visual of the Russian nesting dolls to give you some sense of the complexity of the theory of criminality with which Mr. Trump was faced in New York. This first doll represents the actual charges in the indictment against Mr. Trump. There were 34 charges of felony falsification of business records under New York law. And to make it a felony falsification, you have to meet all of the elements of misdemeanor falsification, which means you have to have a falsified business record with an intent to defraud. And then to make it a felony, you have an additional element that must be proven. That additional element is the intent to commit another crime. All right, so the next nesting doll is, what is that other crime that Mr. Trump intended to commit? Well, Mr. Trump wasn't sure, and neither were his attorneys, so he asked the New York prosecutor for what's called a bill of particulars, saying, hey, please tell me what that other crime you think it was that I intended to commit. The prosecutor interestingly responded and said, hey, you don't have a right to know. We don't have to tell you what that specific crime was. And oh, by the way, without limiting the people's theory at trial, that's a direct quote. In other words, without limiting our ability to change our minds during the trial, the other crimes that Mr. Trump may have intended to commit may include one of four things. First, New York election law. Second, New York tax law. Third, falsification of other business records, presumably other than the 34 with which he was actually charged. And finally, the Federal Election Campaign Act, FECA, right? Now, if you hear me list those four possibilities of the other crimes Mr. Trump intended to commit, you see that they're very different crimes, right? They range from state crimes to federal crimes, from misdemeanors to felonies. And within each of those crimes, there are different, or statutes, there's different sort of ways to commit a crime. So for example, under New York tax law, tax fraud was one of the statutes cited by the New York prosecutor in his response to the bill of particulars request. That tax fraud can be committed in multiple different ways under that statute. There's different kinds of ways to engage in tax fraud. FECA, as you probably know, it's the Federal Election Campaign Act, is a federal law that's over 100 pages long. And if you read it, you see that there's lots of different crimes embedded in that one mega statute. So Mr. Trump didn't know for sure what was that other crime that the prosecutor thought he intended to commit. And in fact, the first time he learned what it was during the jury instructions, when Judge Juan Merchan told the jury that that other crime was New York election law, okay? That's far too late for due process purposes, for purposes of notice, right? That's after all of the evidence has closed. All right, so then he picked out, of those four that were mentioned by the prosecutor, New York election law. And when you look at New York election law, you see even further that embedded in it, there's another predicate. In order to violate New York election law, you have to basically interfere with an election by quote unquote unlawful means. And you say, well, what does unlawful means? Unlawful means that the way that you committed the violation of the New York election law was itself unlawful in some way. So there's a second predicate crime buried in there, right? And then you say, well, how do I know what those unlawful means are? And Mr. Trump had no notice of what those unlawful means were because unlawful means was embedded in the New York election law, which he didn't even know was the first predicate for the basis of the felony falsification charge. And the first time Mr. Trump realized what the unlawful means could be for the basis of the New York election law was, again, during the jury instructions by Judge Merchan. And at that point, Judge Merchan instructed the jury, and I wish I had 3 of these, but I only have 1. I got these in Russia, actually. And the 3 means that Judge Merchan pulled out of the sky, right, were number 1, FECA, again, the federal election law. Number 2, falsification of other business records, although he didn't specify which ones. And number 3, and this is kind of fascinating, quote unquote tax laws, which Judge Merchan's instructions said could include not only state law, but federal tax law and local tax law as well. Now, to make matters worse.
You can finish up real quick. I apologize. We got just a,
Pull it up.
yeah, if you can finish up real quick.
Sorry. To make matters worse, Judge Merchan instructed the jury that they need not be unanimous in picking out which one of these 3 means by which they could convict Trump. This is a travesty of justice. It's clearly a violation of due process. And if anyone would like to ask me about
Mr.
the
Chairman,
Supreme Court's
point of order.
decision in Shad on unanimity of means,
Point of
I'd be
order, Mr.
glad
Chairman.
to give further detail. Thank you.
Here, how antithetical to that is to due process?
Well, I think when you piece all those pieces of evidence together, they paint a pretty compelling picture of bias. And, you know, whether or not it would shock, you know, the left side of the aisle's conscience, I don't know, but it certainly would shock mine. I'm trying to be pretty objective about this. You know, it's a high bar to shock someone's conscience, but, you know, basically the idea is, you know, if you're doing the Attorney General Justice Jackson maneuver of picking the man and pinning some crime on him, then yes, I would hope that would shock your conscience.
Thank you. Yield back.
Gentleman,
I have some UC requests.
Gentleman has a unanimous consent request.
Thank you. Article from CNN, former President Donald Trump announces White House bid for 2024. Article from The Hill, Biden suggests Trump will not take power again if he runs in 2024. New York Times article from December 5th, 2022, Manhattan DA hires ex-justice official to help lead Trump inquiry. February 7th, 2023, Pomerantz versus Pomerantz, an annotation of his leaked resignation letter in Manhattan DA Trump investigation. Piece from Business Insider, Donald Trump again teases 2024 presidential bid, saying he'll make a big announcement on November 15th, same day Mike Pence's memoir is scheduled to be published. February 23rd from the New York Times, 2 prosecutors leading New York Trump inquiry resign, clouding case's future. May 6, 2021, FEC drops case reviewing Trump hush money. From Washington Examiner, for prosecutor Bragg, Trump indictment is campaign promise kept. And piece, Biden's number 3 man at DOJ resigned to join Alvin Bragg's Get Trump team on November 18th, 2022.
Without objection.
Thank you.
Gentleman from California is recognized for 5 minutes.
Thank you, Mr. Chairman. Of course, the leftist lawfare didn't start here. I think it started when the Democrats used the IRS to target Tea Party volunteers for harassment and intimidation in advance of the 2012 presidential election. In the 2016 presidential election, the FBI, the DOJ, and our intelligence agencies used their power to legitimize the lie that had been concocted by the Hillary Clinton campaign that Trump was colluding with the Russians. Despite knowing this was a lie, these agencies used their powers to legitimize it, to authorize spying on the Trump campaign, and to terrorize its supporters. And when this failed, they continued to pursue it, to undermine the Trump administration, question the legitimacy of the election, and shook this country apart for more than 2 years before the lie was finally fully exposed to the public thanks to the Inspector General's reports. Then we have the 2020 presidential election. Hunter Biden laptop contained emails that clearly documented long-standing influence peddling scheme involving the Biden family, in which millions of dollars were paid. Yet 52 high-ranking intelligence agency officials signed a letter circulated by the Biden campaign calling it Russian disinformation. And although the DOJ had that computer in its possession and knew it was authentic, they suggested otherwise and then used their power to pressure social media companies to censor and suppress that story. Pollsters have reported that action alone could have decisively influenced the 2020 election. And now we have this. And I'm sorry to inform the ranking member, but Jack Smith was one of the principal figures in the IRS scandal. He had a history of prosecutorial misconduct, culminating with unanimous reversal by the U.S. Supreme Court. Yet he was the one appointed by the Biden administration to try to put their chief political opponent in jail. Biden's attorney general personally approved a raid on a former president's home despite strenuous opposition by career DOJ officials and by the local field office that would normally have had jurisdiction. Alvin Bragg, who campaigned by boasting he'd prosecute Donald Trump, was joined by the number 3 official in the Biden Justice Department. Nathan Wade, named prosecutor by his paramour, Atlanta DA, spent 8 hours consulting with the White House counsel at the White House before filing these felony charges, not to mention the multiple failed attempts by Democrats to throw Trump off the ballot. This administration and its Confederates have broken every political norm, every civil tradition, every due process protection that shielded Americans from the convulsions suffered by banana republics. And we can now clearly see the full power of leftist lawfare. We always thought this couldn't happen here, but it has. And my question is what can be done by Congress, first of all, to close this Pandora's box and assure that it is never opened again? Mr. Bailey?
I think this body has a duty to erect a wall of separation between tech and state to prevent government censorship of conservative voices on big tech social media platforms. As you pointed out, the deep state has actively suppressed information that interfered with the 2020 election. I think that will continue to happen as we move into 2024, and I think the distinguished member is absolutely right that we've got to stop looking at lawfare in terms of trees and start seeing the forest for what it is. It's censorship, it's civil suits, it's President Trump being unconstitutionally stricken from the ballot in states, it's now criminal charges.
It's the turning of the most terrifying powers that government possesses against its own citizens to influence elections. And this has been going on now through several cycles, and now it's getting to a whole new level. Mr. Traynor?
Thank you for the question. I think it really comes down to the fact that we have to get away from allowing government to be the weapon to interfere in political participation.
How do we do that?
I had the opportunity last year to testify before the House Administration Committee on this very issue of how complaints are filed with the Federal Election Commission and used to do nothing but go investigate political opponents under the guise of the federal government conducting that a legitimate investigation, and they ultimately turn out to be nothing at all. In fact, the most infamous one that I talked about was a gentleman who spent $348 on a Facebook page. The allegation against him was that he had spent $23,000 on a Facebook page, and he spent 3.5 years being investigated.
Right, and word gets out to anybody else, don't even go near the political process because you will expose yourself to this kind of liability. I know Tea Party volunteers who today won't go near politics for fear of invoking the harassment of the IRS. What really frightens me is what happens to our country when Trump, if Trump narrowly loses the election and the case is then overturned and repudiated and exposed by the higher courts. That could tear our country apart. Ms. Foley, final word?
Well, I mean, I think there are a few things that at a minimum should be done. One is to defund the district attorneys and actors who engage in these nefarious acts. Two, I think the Congress needs to use its oversight authority. It has clear oversight authority under the Civil Rights Act to make sure that law is not weaponized to prevent people from exercising their First Amendment freedoms and other constitutional rights. And I think that's really a pattern that's going on today. I think there's mass intimidation through lawfare and other means to intimidate, especially those on the right, from speaking their mind, from gathering, from assembling, from protesting. I think also we're, to a certain extent, we're late to the game as conservatives and Republicans, but we have to start engaging in lawfare of our own. I think there's various ways, for example, that Mr. Trump, if he wants to.
Well, my time is up, but I hope we don't do that. We must never allow the left to become our teachers.
Well, but there's good lawfare and there's bad lawfare.
The time of the gentleman has expired. The gentlelady from California. By and allowed a state officer to assert federal jurisdiction where they themselves had taken jurisdiction and couldn't prosecute. I want you to unpack that sentence for us again real quick.
Thank you, Mr. Chairman, for the question. The Department of Justice, all of these claims with regard to the $130,000 from Ms. Daniels stem from a complaint that was filed at the Federal Election Commission following the 2016
But
election.
you guys were investigating.
We were in the process of investigating that.
The DOJ came to you and said, stand down, we're taking over, and give us your information.
They asked us to abate that and several other
DOJ
matters.
meeting the Southern District of New York.
That's correct.
They took your information, and you guys, you voted to stand down and give it to the federal authority, right?
That's correct, Mr. Chairman.
And they determined that there was nothing there to prosecute other than Michael Cohen. the
That's
star
correct. Now,
witness in
they
this
took
campaign.
they took a very long time in doing it, and when they sent it back to us, we had no more authority to investigate because they sent it back to us, and we were barred by the statute of limitations from even investigating the normal civil things that we would look at with regard to those type of expenditures.
But your point here is they've said idly by and allowed a state officer to assert federal jurisdiction where they themselves had intervened, to use the word, and taken jurisdiction from you and concluded there was nothing there regarding a federal statute, right?
That
and
is
a, quote, federal crime that they come up with somewhere.
That is correct, Mr. Chairman, and I don't know what role Mr. Coangelo played in that investigation that took place when they took it away from the Federal Election Commission, did that investigation, and then he later left the office to go prosecute this at the state level.
Well, we're going to find that out on July 12th when Mr. Colangelo will be sitting in your seat and Mr. Bragg will be sitting in Ms. Foley's seat, and we'll get a chance to ask him. Ms. Foley, Mrs. Foley, excuse me, the Democrats talk about, jury of his peers. Okay, fine, that's how our system works. But if President Trump didn't learn what the unspecified crime was until the jury got the instructions from the judge, that sort of changes the dynamic a little bit, doesn't it?
Yeah, it's not blaming the jury. I mean,
Of course.
the jury, has to operate according to the instructions provided by the judge. The poison here, the poison pill, are the jury instructions themselves, which provided the notice, but it came too late for purposes of due process. So yeah, I mean, you can't correct that through a bad set of jury instructions. If there's a due process defect because he learned too late, you have to redo the trial. You have to reverse the conviction, and then the prosecutor has to decide if they want to. Yeah.
I was an economics major. I majored focused on wrestling, but you had to get a degree. I got one in economics, and they talk about this opportunity cost. If you don't know what the issue is, you miss the opportunity to maybe focus in on the issue as the defense counsel, right?
Yeah.
That's kind of important, particularly when you're talking about what kind of sentence they may try to impose on the president on July 11th. That's kind of important, right?
It's kind of important, and I would suggest that any member of this committee who faced similarly amorphous charges or a loved one would be absolutely incensed by facing these kinds of charges, where it was a moving target.
You're not the only constitutional scholar who's raised this concern, this, I think, huge concern. Mr. Dershowitz, Mr. Turley, other esteemed constitutional scholars have said the same thing.
I'm in good company. I think there's a general consensus that there are some due process problems here.
You sure are. Mr. Attorney General, July 15, 2021, Alvin Bragg. I'm the candidate in the race who has the experience with Donald Trump, and I think it'd be hard to argue with the fact that that'd be the most important, most high-profile case, and I've seen him up front and seen the lawlessness that he could do. That's what he said as a candidate. Does that fit with kind of the ethics of someone who's a member of the bar and running for a district attorney's position? Is that how you're supposed to conduct yourself in a campaign?
Absolutely not. That abhorrent statement is an incurable impropriety that should have disqualified Alvin Bragg from prosecuting that case.
Yeah. Not to mention, then when he gets the job, he looks at the facts, looks at all the evidence, and he concludes, like, this case, I shouldn't prosecute it. I should do what the Federal Elections Commission did, not prosecute. What the Southern District of New York did, not prosecute. What my predecessor, Cy Vance, did, not prosecute. That's what he wanted to do until the political pressure came. They talk about us all the time, pressure. Came from the left. Mark Pomerantz left his job, volunteered, goes and becomes an assistant district attorney to go after President Trump. And then when Alvin Bragg gets there and looks at how crazy the case is, and Michael Cohen's going to be their star witness, he goes, this is crazy. I'm not doing it. I'm not that crazy. But then they leak, Pomerantz resigns, leaks the letter, and all the left goes crazy. And Alvin Bragg says, now I'm going to do what I said during the campaign, even though I know it's wrong. And that's what happened. And then they got a judge who went along with all the crazy things Ms. Foley's pointed out. That's the story. And that story is consistent with the facts. That's why we're here today, and that's why we look forward to Mr. Bragg and Mr. Colangelo sitting right where you're at so they can answer our questions.
And I want to make sure I heard it correctly, that you said President Trump's interference in the 2016 election.
Correct.
Is that correct?
That's correct.
That he interfered in the 2016 election?
Yes, sir.
And real quickly, how so?
The jury unanimously found in the Manhattan case that former President Trump had committed 34 felony violations of document falsification.
You weren't referring to anything else.
No, that's not true. That's disinformation, sir.
Yeah, okay.
In order to find that, they were
That's
charged with election interference. The underlying crime that made that a felony, not a misdemeanor, was election interference. Same pattern as 2020.
So it's all about election interference in 2016 also. Ms. Foley, so we heard from the gentleman that's to your right that he said that the DOJ should be viewed as above reproach because, look, they prosecuted the president's son. A year ago, weren't they cutting a sweetheart deal? Do you recall the details of that?
Yeah, I mean, they were basically just going to let him walk for all of them. They already allowed statutes of limitations to expire on multiple of the more serious felony.
So how did that happen that we actually may get justice in that case?
Well, I mean, look.
Wasn't it the judge that
you know,
threw out the sweetheart deal?
Yeah, I mean, you had a judge in Delaware that threw out the sweetheart deal, yeah. And then, you know, I guess there was egg on the Biden administration's face, so they felt like they had to do something, so they pursued these current charges, the gun charges and the tax charges. But, you know, I mean, did they reach the right result? I assume so. I didn't follow that trial very much. I think there'll be an interesting question as to whether the president commutes his son's sentence, so we'll see.
Which is, yeah. So, also the gentleman next to you referred to under questioning, he said this trial and jury was scrupulously fair. It was outstanding. There was nothing unusual. Care to comment on that?
Well, again, I mean,
You could start with nothing
I'm not
unusual.
blaming the jury here. I think the poison came from the behavior of the prosecutors hiding the ball, and then Judge Merchan giving sort of a cafeteria-style approach where non-unanimity was allowed on the underlying means by which the New York election law was violated. I think those are clear due process violations. So it's not the jury's fault. They just had, you know, junk to work with, so to speak. I was going to use another word, but I probably shouldn't.
It's almost enough to shock the conscience, huh?
It's almost enough. Yeah, it shocks mine. I don't know about yours, but.
I believe it's correct, and I can be corrected on this if I'm wrong, but I believe the judge contributed to President Biden, the judge in this case. Is that common for a case that has a real nexus that the judge would contribute and then not recuse?
I've never seen a case like that. I mean, usually a lawyer feels pretty confident if he finds out that the judge has overtly, you know, expressed preference for one party or another, and political contributions to the Biden administration would seem to fit that bill, given the political overtones of this case, right? This was not an ordinary state prosecution. This was a state prosecution that, if successful, even though it had been turned down at every other level to even proceed as a prosecution, if it proved successful, it would basically interfere with the 2024 presidential election. And possibly that interference could not be remedied, could not be rectified until after the election. So it's slam dunk 2024 election interference.
It's almost reminiscent of Jack Smith and Governor McDonnell in Virginia, isn't it?
Right, and he got his you-know-what handed to him by
Yeah.
the Supreme Court on that one.
I want to get a question into Attorney General Bailey here. Talk about the overall chilling effect in regards to this. In fact, I believe it was Governor Hochul after this charge happened, went on media in New York and said, "Hey, don't worry. This isn't going. We're not coming after the rest of you business people. This is just Donald Trump." Talk about the impact of something like this for the long run in the rule of law.
The Constitution is our national identity. Those rights codified therein come from God, not man, and the document is intended to protect us from the government. And yet what we see time and time again is the government being weaponized against individuals. It's President Trump today Who will it be tomorrow? And that's the problem. I think that when you look at the due process issues contained in the charging document, ultimately in the jury instructions, and you look at the inchoate nature of the offenses with these ill-defined levels of attenuation, it's as if invisible links of chain are necessary to connect the facts to criminal liability. And it causes the jury to turn into a roving commission, free to pursue whatever facts they want to attach liability as they please. And the issue there is it undermines the rule of law for the rest of us. Who can have confidence that we know what is and isn't illegal behavior when the court and the prosecutor impanel a roving commission to attack a political opponent?
I yield back, Mr. Chairman.
Gentleman yields back. The gentleman from California is recognized.
I want to begin by quoting the jury in the Manhattan hush money